The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you.
Thank you.
Welcome to the Appeals Court. I am Justice Meade. With me today are Justices Englander and Walsh. The case is 2022 P742 Edward Vallery versus Joseph MAURO. Mr. Padalero, go right ahead.
I thank you, Judge. As you can see in this brief, this case involves a stabbing incident that occurred at the Sons of Italy. And I did write down the date back in 2019, 11/24/19. On that date, they were both customers at the Sons of Italy. A verbal dispute occurred inside the establishment. Mr. MAURO left earlier. My client stayed for a bit. Upon leaving the premises, my client just got out into the entranceway, and Mr. MAURO was waiting for him and stabbed him twice.
Counsel, we're, I think, familiar with the facts. If I could just cut to the chase as to what questions, at least I have, and I'm sure my colleagues may have some as well.
Sure.
I read the motion to amend. I read the motion for reconsideration, and I looked at our record. I do not see any record of a transcript of the assessment of damages hearing. Is that correct?
I do not have a copy of that transcript, Judge. That is correct.
You assert in your brief that a person presented himself as the defendant at the assessment of damages hearing. Is that correct?
Yes, the defendant showed up for 2 hearings. The defendant showed up at the first assessment of damages hearing in front of Judge Frisson, I believe her name is.
September of 2021, he showed up. He asked to have a lawyer present. Is that right? And so it was continued?
Yes, he wanted to remove the default. He wanted to get a lawyer and what have you. I did oppose it.
Is there a record? Is there a record of that hearing?
No, not in my materials. I mean, we were in court. That was a court hearing.
And then in November again, he showed up again in November?
Yes.
And your client testified at that hearing?
Yes. And Mr. MAURO cross-examined him.
He did actually cross-examine him?
Yeah, it was, I don't want to say, he wasn't familiar with the damage remedies. He was upset that medical bills were there, and as far as he was concerned, that wasn't proper. So,
if you will, counsel, I'm trying to, the difficulty that we have, and that consequently you have, is that our review in this case of this appeal is of the record that was presented to the trial judge, Judge Wilkins. And as I understand it, you filed a motion to amend, and you filed a motion for reconsideration of the denial of that motion to amend. Neither of them included a transcript of this hearing, correct?
Of those 2 hearings, that would be correct.
Okay. And in fact, I looked at them. Did you have a hearing before Judge Wilkins, or was it decided on the papers?
Papers.
So looking at your papers, they did not identify, and correct me if I'm wrong, I'm trying to make sure I understand the record. The papers submitted to Judge Wilkins did not say the defendant showed up and cross-examined at the assessment of damages hearing.
I think that's correct.
Okay.
Well, let me ask something related to that. Does the docket sheet reflect that Mr. MAURO was at the hearing?
Hold on. I think the answer to that is yes, but I just want to double check. All it says in the docket, Judge, is assessment of damages hearing scheduled on 9/16/21 has been held as scheduled. Comments and continued. Comment and continued. Honorable Judge Frisson presiding. It didn't say he did appear at that hearing, and that's why it was continued.
Right, so we don't have a record in the docket sheet that I could see indicating that the defendant showed. Now, when you're filing a motion for to amend, I suppose one might assume that it's going to go to the same judge that decided the assessment of damages, but that's not what happened. It went to a different judge who had none of the knowledge that you had, and it wasn't provided to that judge. So Judge Wilkins, when he got your motion, didn't know that the defendant had appeared and wasn't told that the defendant had appeared. And so he said, quite understandably, looks like two different people to me, and I'm concerned about due process. Isn't that what happened here?
I can't say what the judge was thinking. He didn't say what the problem was. He
No, he
said
said exactly what I just said. I paraphrased it, but he said, I'm not convinced that Joseph MAURO Jr. is the same person as Joseph MAURO, and I'm concerned about due process.
He did say he was concerned about due process. I don't dispute that, Judge, but I couldn't quite gather what his concern was.
Well, he has nothing in the record before him that indicates that the person you wanted the name changed to had actually been served with the complaint. He had nothing in the record before him to indicate that that person had ever appeared. So he did not know that it made sense for him to do that. And I think that's what happened. And that's why I wanted to ask the questions that I did. It's a Superior Court hearing, right? So presumably there is the capacity to obtain the transcript that you've described to us, but that is not in our record.
Sure, I don't deny that.
Okay. Okay. I'm sorry. I know I derailed your argument. So if you have things that you'd like to tell us, please do.
Well, I guess in highlighting the brief, I mean, motions to amend to reflect the state of the evidence are allowed. I don't know if I would use the word routinely, but commonly. And when the two cases that I've cited, and the labor case and the art case, I mean, those examples were, I don't know if you want to call it 100 times more extreme. The art case, it was an 18-year delay. They knew the defendant to be Luigi, I think it was Gaglini, and they named instead a Baglini, Gaglini. And they knew that was incorrect for 18 years. And the court said, well, we're not going to allow, there seems to be some sort of fraud in that case. They don't explain what the fraud is, need not matter. And they said they're not going to allow the defendant to escape with his wrongful conduct. You do, in my case, obviously you have an attempted murder. That's what the criminal charges are. I would consider that more severe than fraud. And when you look at what Judge Wilkins did have before him, I think I attached the criminal to one of my motions, the criminal investigation. And
Did you attach the police report? I could not determine whether that was attached. The police report actually says true name, Joseph MAURO Jr. And the police report was attached to the motion for attachment.
yes, and but when you look at beyond the police report, it did say true name Joseph MAURO. Throughout the police report and the investigation, Joe MAURO Jr., throughout the police report and the investigation, they never used Joe MAURO Jr. It was always Joe MAURO. And the police also point out to the address being the same, the date of birth being the same, and the information that I have is the same. Indeed, when we were in court.
Did you identify a date of birth in the complaint?
Of
I mean,
Mr.
how does the judge know that the date of birth of Joseph MAURO Jr. is the same as the date of birth of the person you've sued?
Oh,
The
in my
judge
complaint,
you
I did
asked
not list
him-
the date of birth, Judge.
Yeah, okay.
So, counsel, let me just ask a quick question. In your motion for reconsideration, you make an argument that the defendant held himself out to be Joseph MAURO, that he himself didn't include the name Junior, and you attached to your motion for reconsideration, I think it looks like a Yelp search, including his business address and his home address, that never includes the name Junior. So is it my understanding that your argument is that if the defendant holds himself out as no Junior, Joseph MAURO, that's sufficient enough?
I don't think,
Yeah.
when you say sufficient or enough, Judge, what I say is it is indeed the same person. And obviously it isn't enough because there was a Junior on the deed. So, but what I am trying to say is when you look at the body of evidence here, it is quite clear that this person is the same person. And the same address on Whittier Street in Medford, actually.
Yeah, but he could live with his father. One thing that seems relevant to me is your client was in the courtroom and testified at the assessment of damages hearing, right?
Yes.
And your client knew Joseph MAURO, who stabbed him, right? He knew
Yes.
him from the police reports. He knew him before he was stabbed.
True.
So this transcript could easily have in it materials that indicate that's the guy who stabbed me, or, you know, something like that.
Well, if anything, I think what the transcripts would have, again, Mr. MAURO was there at no time before Judge Liu for this, the assessment, and before Judge Frisson, at no time did Mr. MAURO ever say, it's not me. This was my father, my cousin, anything like that. I mean, he asked for time because he had he acknowledged the fact that he had a lawyer for the criminal case. He said that wouldn't be the lawyer for the civil case. He asked for time to get a lawyer for the civil case. My response was, if you want to remove a default, you have to have a meritorious defense, and he's on camera stabbing my client. But at no time did he say that this isn't me.
Can I ask another question?
Sure.
What happened with respect to the execution? You had a judgment. You also had an attachment against Joseph MAURO that I guess had been recorded in the Middlesex County Registry of Deeds. Then what happened? You tried to did you try to seize the property and execute on it? What steps did you take, and how did you learn that the names didn't match?
Well, what happens, Judge, is oddly here, the first execution was issued, the clerk's office misspelled Mr. MAURO's name. I had to return that to spell it properly. It did come back. Then I gave the execution off to the sheriff, you know, to what's the phrase? Levy and stay, you know, serve it on the registry of deeds, but I wasn't gonna sell. I can't sell because also on the deed is Mr. Murrow's wife's name. So
Yeah,
that's,
okay.
but it was that sheriff, the second sheriff, who said, I don't, well, he didn't talk to me, he just returned it, said, the name JR is here. So he did not serve it upon the registry.
Okay. All right. Thank you.
Thank you, Mr. Padalaro.
All right,
We'll take
thank
it under
you.
advisement.
Thank you very much. Everybody have a good.
I'll send a separate link